I want to talk about one area of real estate today, and that's when multiple parties own one piece of real estate as joint tenants or tenants in common. Now this can happen in estate planning cases where someone leaves land to their heirs under a will. Suddenly, let's say 5 children become the owners of a farm. If they didn't use a trust, then it passes to the children under the will and they all own a 1/5 undivided interest in the farm. Well, what happens when the 5 children cannot agree on what to do with the farm? Let's say 1 wants to keep and farm it, 2 want to sell it, 3 want to turn it into a housing development. They can't agree. Well, this is why I recommend using trust planning to dictate what should happen to the farm after you're gone. However, if the children become 1/5 owners under this scenario and they cannot agree on what to do, then the option they're faced with is going to the court and asking for a partition action, meaning they would literally ask the court to partition the real estate into their respective fifths so they can do with it what they wish. So the court then would decide where to draw the lines and who gets which piece of the farm. You can see where this can destroy value inherent in some real estate because some things are not easily divided. A farm might be able to be divided, but it's arguable that all pieces are equal. On many farms, perhaps this parcel is worth more than this one, etc., and often together it's worth more entirely. You can also think of other things that wouldn't lend themselves well to partition. For example, a commercial office building or a commercial real estate development site where you want one plan for the whole thing. So think carefully before you leave real estate to your children outright. If your plan is for them to use it to produce income or you have some real estate development plan, it's better to leave and plan a plan to manage the property and for what should happen to it after you're gone than to leave it to them jointly and risk creditor claims and the possibility of disagreement where you need a partition action by the court. So that, in short, is a partition action.